I'm Sabrina with the 2-Minute Washington Hospitality News you need to know. Tip pooling is our topic today, namely because the Ninth Circuit Court of Appeals denied a petition in an ongoing tip pooling lawsuit. So what does that mean? The Department of Labor has the authority to regulate tip pooling practices of employers who do not take a tip credit, and employers cannot include non-tipped employees in mandatory tip pools. Because of this, Washington Hospitality's advice is to change tip pooling practices so you're in compliance with DOL's tip pooling rules. Now that, understandably, leads to another question. What tip pooling models comply with DOL's rules? Well, here are 4 brief options. A mandatory tip pool that only includes customarily and regularly tipped employees. Important factors are where in the restaurant the employee performs their duties. As a general guide, positions that engage with customers regularly can be included in mandatory tip pools. Management cannot. Kitchen employees typically cannot, but there are some exceptions. The next option is a voluntary tip pool. If it's truly voluntary, then it can include some employees who would not be eligible for a mandatory tip pool. As you can imagine, this can get a little tricky. Voluntary systems are frequently under scrutiny and are challenged as not being truly voluntary. A third option is to have a way for customers to directly tip back-of-the-house staff. For example, there could be 2 tipping lines on a receipt, one for service staff and the other for kitchen staff. The fourth and final option is to implement a service fee. This is handy because it's not considered a tip, so it doesn't fall under DOL's regulations, which means the fees can be shared however the employer chooses. Now, no matter what method you decide to use, it's recommended that you work with an attorney to make sure that your tip pooling complies with the law. For help, contact Washington Hospitality. That's our 2 minutes. I'm Sabrina. Thank you for watching.